And so we are saying he should resign now or that the president should fire him. Number two, we've also demanded a full-blown, publicly televised parliamentary inquiry. You know that members of parliament have the power to censure any minister of state who violates the constitution or their oath of office. Clearly, Dame has violated his oath of office and the 1992 constitution. He has engaged in crime. He has engaged in unprofessional conduct. And we are saying that if the president refuses to remove him, this matter should be probed, not just this matter, but other allegations of judicial manipulations by this Attorney General. Because if he can do this, who knows what he can do? The desperate lengths he can go just to pervert the course of justice. Let's probe all of that and censure him. Parliament has that power. Number three, we are calling for the immediate commencement of disciplinary proceedings by the General Legal Council, the body that has supervision over lawyers in this country, to hold Godfred Dame liable, to first of all investigate that matter, give him a right to be heard, and to go into the issues. And if he is culpable, to impose the necessary sanctions on him, because Rule 13 is clear: a lawyer cannot or is not supposed to communicate to a represented party on the blind side of the lawyer or the represented party. You need, at all material times, the consent of the lawyer, or the ideal situation is to communicate with the lawyer, because the represented party is not a lawyer. That is a presumption. And so you, as a lawyer, can take advantage of him if you engage in any negotiations or discussions with him. And that is why our ethics as lawyers enjoin us to go through the lawyer once he's represented. He didn't do that. He has engaged this accused person, Mr. Jakpa, on countless occasions. Some on WhatsApp, some in phone call conversations, some in physical meetings, and today we demonstrated that to you.
I have some few questions.
But let me just end. So there is a disciplinary proceedings because of the breach of Rule 13, Rule 40, Rule 54.
And that you want the General Legal Council to take
investigate. Then the motion of censorship by Parliament, which will lead to a publicly televised probe, his immediate resignation, or dismissal. And we have also demanded his arrest and prosecution, because he is heard on tape telling an accused person who doubles as a witness before a court of competent jurisdiction to fabricate, forge a medical excuse duty when he knew that that accused person was healthy. He says, go and forge it, go and deceive a court so that I can get an opportunity to travel.
At this stage, because you are a lawyer, I mean, you allow me, if I play around words and say that because the Attorney General has not come out to deny or accept that the voice is his, we will play on the assumption that this is an allegation against the Attorney General.
Well, you can call it an allegation, but I won't call it an allegation in the sense that in courts, you see, this matter is not something that just emerged in the media. You know, the last week, Thursday, the 23rd of May, Mr. Jakpa, the third accused, was cross-examined by lawyers for the first accused, Honorable Ato Forson, right? And in courts, the third accused boldly told the courts that the Attorney General has been calling and meeting him at odd hours, impressing on him to skew his testimony, answer questions in a way that implicates the first accused. And he has told him that he cannot do that in good conscience, because he knows that what the Attorney General wants him to do is untenable, it is false.
We heard the word...
So that evidence...
We heard the word hold on. Do you accept the deal? I don't know what deal the Attorney General was talking about.
So that evidence is not part of the record. And the Attorney General knows the rules of evidence. Section 6 is clear. If he thought that evidence was scandalous, vexatious, whatever, the laws allow him to object. And the law say, the rule says object timelessly. He did not object. And so that is part of the record. And so this being a public proceeding, we can rely on that record. And we have gone further to give you the further and better particulars. That is the hardcore evidence. So this is no longer an allegation. We have all the proof. He can't dispute any. If he disputes, he will have to tell 10 lies to justify every one lie he tells, because we have abundance of evidence. What we have released today is just the tip of the iceberg. Now you were asking me.
I was asking because I didn't hear him clearly say Ato Forson or mention the other name. What I heard him say was that, I mean, just accept the deal.
Yeah.
I don't know which deal he was talking about. So, who in reference this deal reflects.
So he says on the tape that if you accept
the deal.
No, if you accept this, it creates no difficulty for you. If you accept the deal, at another place, he said, if you accept the deal, then at a certain point, when he was impressing on the third accused said, you mean the way you want me to answer the questions or go about it? He said, let's take it like that, the way I want you to go about it. Then you see them referring to his position, the deal, accept this, right? Now, if you listen to the full conversation, you get a context. The context is what Jakpa says, that the reason his difficulty in accepting the deal, which is to testify and answer questions in the way the Attorney General wants him to do, is that it will help the states secure the conviction of an innocent man. And that his conscience cannot allow him to do that.
This is Japa.
Yes, because
the Attorney General.
Yes, because he knows the man is innocent. And the Attorney General continues. The Attorney General said, no, I'm not talking about the first accused.
Exactly.
So, of course, he knows that he's... Because, you see, as we speak, there are only two accused persons. Jakpa or Ato Forson. So if... Jakpa and Ato Forson, first accused and third accused. The second accused, former Chief Director of the Ministry of Health, has been, acquitted, not discharged. No, the state, I think, entered nolli prosequi and discontinued the case against. So the point here is that if he was engaged in that conversation with Jakpa on the 9th of April when there were only two accused persons, who were they discussing?
Assumption.
It's not assumption. It's not assumption because they are talking about letters of credit. And he wants him to testify in a certain way about those letters of credit. And the guy is educating the AG that your understanding of the effect of this letter of credit is wrong. And that those who did this letter of credit did nothing wrong. Because the letter of credit is only security. It is not payment. It has condition precedents. It is only when the condition precedents are fulfilled that the seller can activate for payment.
Right.
The AG, this is trite. Everybody knows this. Yet the AG was still, insisting that he accepts his position, which the accused person says, I know this to be false. I can't accept it. Who wrote the letter for those letters of credit to be established? It's Ato Forson.
Right.
So if you wanted him to give false testimony that he himself knew to be false about the letters of credit, who was he trying to implicate? Ato Forson. So it is not assumption at all.
Right. So you again, I come back to you because you are a lawyer. So how do you situate this conversation between the AG and Japa, knowing very well that there had been an attempt for a plea bargaining, which from what the chairman of the party said, this conversation took place in April 2024, months or years before the plea bargaining had been on the table. Exactly. So the Japa himself wanted...
So what that shows you is that the AG has been lying to the public all along, and that is why he cannot be trusted.
But there are evidence pointing to the fact that letters had been written asking for the plea bargain.
Hold on. I'll come to plea bargain. First of all, when this matter broke in court, the AG issued a statement. At paragraph 2 of that statement, on the 23rd of May, on last week Thursday, they stated that the states and the AG have never met any of the accused persons.
Right.
Neither have they sought their cooperation in any way. Those were the operative words in the press statement. Now we've shown you the evidence that they've met. The cooperation, everything was there. You've seen the evidence. Then they come back and tell another lie contradicting the first lie. That, it was a Supreme Court judge. This is according to the spokesperson of the AG, who invited the AG to his house.
And we heard a name in the recording.
And unknown to the AG, Jakpa walked in. Today we've shown you a WhatsApp conversation between Mr. Jakpa and Godfrey Dame, dated 16th February 2022. Mr. Jakpa was first arraigned before the High Court on the 18th of January 2022 and granted bail. A month after, he texts the Attorney General to thank him for the intervention he made in getting him bail, which is another conversation. And then he says, I would want an opportunity to meet you at your convenience. Then the AG says, I will meet you through your brother. Who is his brother? A Supreme Court judge.
Right.
So when the AG tells you that I never knew this man, it is a Supreme Court judge who invited me to his house, and I went there and this man just came there, he lied. This is how dishonest this man we called Godfred Dame is. This is how dishonest. Now he talks about plea bargain. Look, first of all, you must understand that there is nothing unlawful about plea bargain. Ghana has passed a law. Even before we pass that law, the Courts Act enjoin lawyers to at all times endeavor to settle litigations out of court. So to set proposal for settlement is normal. That is why they will always title it without prejudice. It doesn't mean that I am guilty, but let's settle. Okay? Now, the first proposal for plea bargain or settlement in this matter came from Big C LLC.
The company
that supplied the ambulance. Which company is not even being prosecuted. They are not a party to the case in court.
And so that's the reason why the AG department...
and the letter is dated 27th April 2023. Right? Mr. Dame was arranging meetings with Jakpa 16th February 2022 in the residence of a Supreme Court judge when no proposal for settlement had been made. So if he tells you that, oh, I was engaging him because of plea bargain, that is the word of a liar. Let's stay on plea bargain just for 1 minute.
Oh, right. I appreciate that.
Just for 1 minute. Yeah. Okay. Aside that, you see the evidence of the communication. 17 July 2022. There have not been any proposal or request for plea bargain. 17 July 2022. Now, even when the proposal for plea bargain was made, 3 proposals. One from Big C, the second from Mr. Japa, the third one, revised proposal from Mr. Japa. All of them were rejected by the Attorney General. Rejected.
True.
So the court said, because you have rejected it, you've not settled this matter, I am proceeding to adjudicate the matter. And that is why the matter is being heard in court. And that is why Japa is testifying.
Okay.
So on the 9th of April, when Dame called Japa for 26 minutes and he recorded him, Japa was going to court to testify. There was no plea bargaining, because if there is plea bargaining, the court will give an adjournment.
Absolutely.
That go and negotiate when you get a settlement, and inform the court. That's why the man was going to court to testify. So like those corrupt people, they do in fixing matches. If somebody is coming to court to testify, the AG calls him. Now look, you are coming to testify. This letter of credit will come. No, you have to answer the person in this way. It doesn't create any difficulty for you. The man said, no, that is wrong because of ABC. No. But if you go about it this way, it doesn't create any difficulty for you. If you accept the deal, the man is coming to testify.
We have to go.
And the worst of it, Elton,
yes.
It's not about what the MPP says. The worst of it is that he tells the accused, go and lie to a court, forge a medical excuse duty that you are sick, when he knows him to be well. This man is a criminal.
All right, so...
And he'll be prosecuted one day.
And tomorrow we'll have more time to deal with this matter.
Yeah.
And Samuel is going to be on Top Story on Joy 99.7 FM. We'll also wait and hear from the MPP. The bigger question is the implications of this on judicial integrity and fairness in this country. It's a very big issue that we need to get to the bottom of it. And of course, when the MPP is ready, we'll be with that news conference live here on Joy, and of course on Joy 99.7. Until then, that's been our show for today. My name is Elton Bobe. Have a good evening. Take care as we continue this very important